DUI plea deals in Cumberland County. What you need to know before you sign. So you got a DUI charge in Cumberland County. The DA's office has an offer on the table, and every instinct you have says sign it. Get this over with and move on with your life. I need to slow you down. Because a DUI plea that looks good, looks like a lifeline, can quietly lock in damage to your license, your record, your job, and your exposure if you're ever charged again. One signature, years of consequences. I'm Sean Quinlan. I practice DUI defense in Cumberland County and across central Pennsylvania. This is what you need to know before you sign anything. What a plea deal actually is. In plain English, a plea deal is an agreement to resolve your case without going to trial. You plead guilty to a charge, and in return you get something specific: a lighter sentence recommendation, fewer counts, or a better outcome than the risk of losing at trial. Your case in Cumberland County moves to the Cumberland County Courthouse in Carlisle, and that local setting matters more than most people realize. A deal that looks decent on paper may not be a good deal for you if it does nothing to protect what actually matters: keeping your license, avoiding a conviction, or protecting a professional license like a nurse or a CDL. Here's the thing nobody says out loud. A plea deal is not automatically a bargain. Sometimes it's just a fast way to lock in damage. ARD versus a plea deal. The difference that changes everything. Before we go any further, I want to clear up the single most common point of confusion I see. People lumping ARD and plea deals together like they're the same thing. They are not. ARD, Accelerated Rehabilitative Disposition, is a pretrial diversion program. It's not a guilty plea, and that difference matters enormously. A standard guilty plea usually means a conviction on your record. ARD gives you a path to avoid conviction entirely, and if you complete the program successfully, you may be able to seek expungement afterward. Now, ARD isn't a free pass. There are fees, supervision, classes, and depending on your DUI tier, there can still be license consequences. But in most first offense cases, ARD is the difference between a rough year and a criminal conviction that follows you for the rest of your life. So if you're a first-time offender in Cumberland County and someone is pushing you straight toward a guilty plea without a conversation about ARD, that's the first question you need to ask. What actually shapes your leverage? Think of a DUI like buying a used car after looking under the hood. The value only becomes clear once you examine the details, and the details of your case determine how much negotiating leverage you actually have. Your BAC level. Pennsylvania law breaks DUI cases into tiers: general impairment, high rate, and highest rate. Each tier carries mandatory minimums, penalties the court cannot go below if you're convicted. The higher your tier, the less room a prosecutor has to offer something meaningful. Prior offenses. A first DUI and a second or third DUI live in completely different worlds. Prior offenses increase jail exposure, extend license suspensions, and make sentencing far less flexible. A deal that sounds reasonable for a first-timer can be a terrible result for somebody with a history. The quality of the evidence. Was the stop legal? Were field sobriety tests properly administered? Is there dashcam footage? Were there problems with how a blood sample was handled? Weak evidence is leverage. Strong, clean evidence narrows the conversation significantly. Drug DUI cases are especially complicated. Unlike a breath test number, impairment in a drug case can turn on driving behavior, officer observations, lab results, prescription issues, and expert interpretation. There's a lot more to work with, and a lot more that can go wrong for the DA. What's really at risk beyond the fine? Prosecutors tend to frame plea deals around fines and costs because those are easy to quote, but the fine is usually only one slice of the problem. Here's what a conviction in Cumberland County can actually do to your life. Your driver's license can be suspended, which in central Pennsylvania means figuring out how to get to work, court, school pickup, and treatment without a car. Ignition interlock can add months of costs and daily hassle. Insurance can spike and stay elevated for years. A criminal conviction can appear on background checks and keep surfacing on job applications, rental applications, and professional credential reviews long after court is over. If you hold a CDL, even one DUI can threaten your commercial driving privileges under PennDOT rules. That's your livelihood. If you're a licensed professional like a nurse, teacher, healthcare worker, or contractor, you may have mandatory reporting duties to your licensing boards. A plea that looks manageable in court can create a professional problem that outlasts your sentence by years. Just plead and move on is genuinely dangerous advice if your career depends on a clean record. The three most common plea paths in Pennsylvania. Most DUI resolutions in Pennsylvania fall into one of three predictable paths. Once you see them clearly, the offer in front of you feels a lot less mysterious. Path 1, ARD. For eligible first-time offenders, this is often the strongest outcome. Avoid a conviction, complete the program, seek expungement. The trade-off is real. Fees, supervision, classes, possible treatment, possible license consequences depending on the tier. But ARD is a very different result from conviction. Path 2, pleading to the DUI as charged. Sometimes the offer is essentially plead guilty exactly as charged, and the sentence recommendation is close to what the law already requires. That's not a deal. That's speed dressed up as a bargain. If your record, license, and career take the same hit either way, an offer like that deserves a hard look before you sign anything. Path 3, reduction to a lesser offense or fewer penalties. This is what most people picture. The charge gets reduced, the grading improves, certain counts get withdrawn, sentencing terms become more manageable. Sometimes that happens. But what can actually be reduced depends heavily on the facts, the evidence problems, your history, and how Cumberland County handles cases like yours. Clean stop plus strong chemical evidence plus mandatory minimum exposure equals very little room for dramatic reduction. Weaker proof changes that conversation entirely. How to tell if an offer is actually worth taking. This is the hallway before court moment. Papers in hand, nerves high, everyone around you acting like a quick answer would be nice. That is exactly when slowing down matters most. A worthwhile plea offer should clearly improve your position compared to the realistic risk of fighting the case and losing. If it doesn't do that, it's not a deal. It's just paperwork. Before you say yes to anything, get the exact terms, not the summary version, the actual version, and ask, what exact charge am I pleading to? And is it a conviction? What sentence is attached? Incarceration, probation, classes, treatment, interlock, fines? Will I lose my license and for how long? Is ARD available instead? What happens to my CDL or professional license? How does this look on a background check? Get it in writing. Memory gets fuzzy fast when stress is high, and the terms you heard in the hallway conversation and the terms in the actual document are not always the same thing. When the case may be worth fighting. Some DUI cases look airtight at first glance and get weaker once the details come out. Red flags that can shift the whole picture. A questionable traffic stop, sloppy field sobriety testing, missing dash cam or body cam footage, problems tracking down blood sample through the chain of custody, mistakes in the blood draw process, or weak proof that you were actually impaired at the time you were driving. Actual impairment matters. So does lawful police procedure. If the foundation of the prosecution's case is shaky, that can create leverage for a better offer, or it can support challenging the case rather than folding early. A plea deal should solve your problem. It should not be saving a weak case for the prosecution. The three mistakes that cost most people. Mistake 1, rushing to plead just to end the stress. Court anxiety is real. The urge to make it stop is completely understandable. But a quick plea can create long-term fallout that lasts far beyond the day you walk out of the Cumberland County Courthouse. Relief today can be very expensive tomorrow. Mistake 2, assuming every first offense automatically gets ARD. It doesn't. ARD eligibility depends on the facts of your case, your prior history, whether there was an accident, and other aggravating details. Cumberland County has its own practices around ARD screening. It's my first DUI is just one piece of the picture, not a complete strategy. Mistake 3, forgetting the long game. The smartest way to evaluate any plea offer is to zoom out, look past next month's court date, and ask what the plea does to your record, your reporting obligations, your job options, and your sentencing exposure if you're ever charged again. One decision can echo for years. A DUI plea deal in Cumberland County isn't automatically good or a good deal just because someone put it in front of you. The question is whether it genuinely improves your position or whether it just gets the case off the calendar. Before you agree to anything, get every term in writing and compare your options side by side. That one step can keep you from accepting something that feels easy today and costs you for the next several years. If you've been charged with a DUI in Cumberland County and you want to understand where you actually stand, reach out. Free consultation, no pressure, link is in the description. Subscribe for more straight talk on Pennsylvania DUI law. I'll see you in the next video. Thanks so much.